Chairman, sir. Sir, a very large number of members have expressed themselves at length on the bill which Lalit Bhai has proposed to this Honourable House. Sir, I must confess that not because I happen to represent the state, but for several other valid reasons, to a large extent I myself agree with the spirit of what is stated in the bill itself. There is a desirability today for creation of benches in several states in the country. I also agree with the observations which were made that there is also a very strong case, and the Government of India has taken a position. There is a disagreement between the government and the Supreme Court on this, that we are in favor of creation of a bench of the Supreme Court outside Delhi, particularly in South. I myself hold the opinion that even before we did that, there is a need at least to have some kind of a circuit arrangement for Northeast, where it is extremely costly for litigants and keeping the economy of that region in mind to come for the smallest of matters to Delhi and appear in the Supreme Court. And this reason of desirability, sir, stems out of 2-3 factors. The Justice Jaswant Singh Committee had given 21 factors to be considered. But the principal factors are, is it going to help the process of administration of justice by enabling people to get quicker and cheaper justice? Or is it going to make the whole process of administration of justice extremely costly, time consuming as far as the litigant is concerned? And I must say, I agree with the members who said the consideration here is not and should never be what suits the interest of the lawyers or the bar. The consideration equally should not be, is it convenient or inconvenient to the judges if you ask them to go and administer justice elsewhere? The principal factor has to be on which side the scales in favor of the litigant are weighed. And if we see those factors, Mr. Prabhakar Reddy was reading out from the figures of the pending arrears of cases. I have been making this statement repeatedly. The Supreme Court arrears in the last few years, the last 1 decade, have substantially come down. It had a peak figure of about 1,04,000. It has come down to about 21,000, about 22,000 today. The district courts, where you said there is a grave problem, at least in one sense there is no problem in the district courts. In as much as the arrears are not rising, they are static at a figure of about 20 billion, 2 crores. And therefore, if we had some new schemes, new processes, new procedures, we can beat down the figure. At least the figure is not increasing. The filing in the district courts all over the country, there are about 12,000 courts, and the disposal every year is practically the same. So some steps are capable of resolving the problem. The slowest layer of litigation in this country is the high courts. 10 years ago, there were 19 lakh cases. There was some confusion in the figure. Today, it has crossed 34 lakhs. And on an average, it is rising at the pace of about 1.5 to 2 lakh cases every year. Therefore, the filing in most high courts, there are some exceptions, is much more than the disposal undertaken by those high courts. And therefore, when we look at this whole problem of quicker justice, the most acute problem is the one pending in the high courts. They've become the slowest layer as far as the judicial process is concerned. The second factor, that besides having become the slowest layer, there are states where we have experimented the creation of benches. You have in Maharashtra, besides Mumbai, a bench in Nagpur, a bench in Aurangabad. You have Madhya Pradesh, there has been a bench in Indore, there is a bench in Gwalior, there is a principal seat in Jabalpur. Now, with the creation of Chhattisgarh, we have a bench, we have a full high court as far as Chhattisgarh is concerned. We have 2 benches, though closer to each other, in Lucknow and Allahabad. We had 2 benches in the erstwhile full state of Bihar. There are states where we've had more than one bench. The government has already taken a decision. The bench at Madurai is in the process of being set up. We are also, I must say, in the process of taking a decision with regard to a bench in North Bengal. The question which Mr. Nariman raised, this question of functional integrity of the High Court, as it is referred to, in some cases it is functional integrity, in some cases a different phrase is used. Will the majesty or the authority of the court will look dissected if you have courts scattered at different points of the state itself? What does the experience of these states where benches have been created tell us? Has the administration in any way suffered? Has the administration of justice suffered? In fact, if at all, you've brought, the bar has developed, the litigants are now closer to the courts, the courts are closer to the litigants. And therefore, in large states, the problem is not merely distance. Distance creates several problems. So a litigant in a large state has a difficulty. He not only has to travel a long distance, he has to perhaps hire a lawyer in that new city where the High Court is located. At many places, he has to carry his district level lawyer along with him because the litigant may not be very literate to explain. He has to stay there overnight and arrange for an accommodation for himself. Sir, I was recently been visiting one of the new high courts we have created at Nainital for the state of Uttaranchal. And when I first went to the inauguration of the Uttaranchal High Court, everybody was very pleased that the city had got a court. And one problem we did not realize in a hill state where the economy still has to develop, nobody realized that the hotels in Nainital are probably amongst the costliest in that part of the country. So every time a litigant has to go there, the distances in the hills are such that he can't go and come back the same day. So those hill state litigants have not only to go there but stay overnight. And last time when I went, every litigant, the ones I met were complaining that our litigation has actually become costlier. Because we now have to come to a state where there are tourist hotels, we have to stay in those tourist hotels, find some cheap hotels for ourselves. Now this is the difficulty for a litigant that travelling to a high court prevails. And therefore, there are several considerations which will have to be borne in mind. And therefore, the distance factor and the problems that it can create for the litigant is perhaps one of the most crucial ones. Now, this demand has been coming from several states as far as the country is concerned. And one of the reasons, I must confess, I have tried to analyze this whole campaign which has started in different areas for creation of benches. What are the real hurdles? Why is it that these demands are not met? And I'm being candid about it. I think we ourselves actually create the first problem. We create the first problem because when demands start rising, instead of objectively assessing which is the center where a bench is required, a high court, as Dr. Singhvi rightly said, can't be in every district, it can't be in every division. Therefore, it may be desirable in some states outside the principal seat to have a bench of the High Court. But when competitive politics takes over, we start almost demanding it in every second district of the state. And therefore, if there is a proposal under consideration in one part of the state, a competitive demand from the other part of the state will also arise. In fact, I have not the least hesitation in saying that in West Bengal, even though a very strong case for a bench in North Bengal has been made out, some delay has also been caused by the fact that two competing districts have actually been demanding it, and those districts are perhaps within 40 to 50 miles of each other. This is a legitimate problem which arises, and therefore those in the position who have to decide start thinking that will it open a Pandora's box, and that is when this whole argument from the judicial fraternity comes. Well, the functional integrity will be destroyed because if one bench is created, every third district is now going to ask for demands as far as those districts are concerned. And therefore, we will have to objectively assess as to which are the areas where benches are required. The second difficulty, sir, as far as Rajkot is concerned, in the year 1983, the Gujarat government had appointed a committee headed by Justice Palekar. Where are the benches in Gujarat required? Because there have been demands from different centers in Gujarat outside the principal seat, which was originally in Ahmedabad and has now been recently located probably closer to Gandhinagar. The Justice Palekar Committee in 1985 returned a report saying that they did not see any reason in having a bench outside the principal seat. The then government had accepted the report. But in the 90s, the position substantially changed, and governments in Gujarat also have been recommending the creation of a bench outside the principal seat. And when this demand has been arisen, various consultations are to take place. Justice Ranganath Mishra said that the high courts themselves are competent and no legislation is required for the purposes of creation of circuit benches are concerned, and these experiments actually should be tried in some parts of the country. I quite welcome this suggestion. But recently, another difficulty has arisen. In the context of Karnataka, that's one of the bills which is listed as item number 3, and we are going to debate when time permits. This issue was also taken to the Supreme Court because a large number of states have been created either under the States Reorganization Act or under some special reorganization acts which were enacted. Now, all the reorganization acts, section 51(3) of the States Reorganization Act, and in the context of Gujarat, section 28(3), the Bombay Reorganization Act by which the state was created, have identical provisions with regard to the creation of benches outside the principal seat. In the context of Karnataka, where the States Reorganization Act was involved, the Supreme Court had an occasion to consider a petition by one of the bar associations from Karnataka. And I'll just read one paragraph out of the judgment that the Supreme Court delivered. The High Court is best suited machinery to decide whether it is necessary and feasible to have a bench outside the principal seat of that High Court. If the High Court does not favor the establishment, it is pernicious to dissect a High Court into different regions on grounds of political or other consideration. So it is out of question, and I am repeating it, so it is out of question to decide for establishment of a bench outside the principal seat of a High Court, contrary to the opinion of the Chief Justice of that High Court, which has been formed after considering the views of his colleague judges. Therefore, the effect of this judgment effectively is
he is pointing out, the Law Minister, the kind of
the
difficulties.
Karnataka case also arose out of a demand for creation of a bench in North Karnataka. There is a principal seat in Bangalore, a seat in North Karnataka had to be created in Dharwad.